viewed debates in the Parliamentary Assembly of the Council of Europe, and I've always been impressed by the quality of those debates. I'm not very impressed by the quality of this report. The main role of the Parliamentary Assembly is to undertake investigations and to make recommendations to the member states of the Council of Europe. And I'm here to appeal to the members of the Parliamentary Assembly to soundly reject the resolution entitled "The Protection of Minors Against Excesses of Sex." As a human rights advocate, I am certain that this resolution would not offer children any meaningful protection not already available to them under the laws of member states. But if this resolution were to pass, it would itself constitute a threat to children, as well as adults, who are members of minority religions. It would stigmatize them and increase the chances of them being exposed to prejudice, discriminated against, and even subjected to violence. The proposal raises the obvious question: why focus just on so-called sects? If the authors of the resolution are really concerned about threats to children, they have to look at mainline religions also. The resolution would be a strike against religious toleration and thus a strike against democracy and human rights, which mean nothing if religious groups are not treated equally. I think this resolution would be a stain on the Council of Europe. It is in no way consistent with the intent of the founders of the Council of Europe. Indeed, it is confusing that such a document, one that would weaken human rights protections and possibly inspire human rights violations, is even under consideration. And I hope after we make our presentations, if there are any supporters of this resolution here, I would be very happy to hear from you so that I could understand better what's it all about, what's motivating this. Because the facts don't seem to support the need for such a resolution. An impressive list of independent human rights organizations and those that monitor religious freedom issues in particular are calling for the rejection of this measure. They are doing so because they understand that the work of defending human rights is often that of defending the rights of members of minority groups, linguistic, ethnic, racial, political, sexual, or religious minorities whose rights and security are often threatened because of discrimination and prejudice. Indeed, the whole philosophical edifice of human rights emerged with recognition of the moral obligation to respect people's dignity, not because they are members of one's own kin or share one's religion or nationality or ethnicity or race, but because they are simply human beings. It is a central tenet of the Judeo-Christian tradition. Pluralism gives us our appreciation for the dignity of humanity as such and for the universality of human rights. We believe this resolution violates the principle of the state's duty to neutrality in matters of religion or belief, treating some with greater suspicion than others and stigmatizing their members. Let us apply a simple test, the test of the golden rule. How would you feel as a member of a so-called sect if Europe's guardians of human rights passed this resolution? If members of the Council of Europe acted on the recommendations to engage in an assault on religions classified as so-called sects? Indeed, the human rights community has many times condemned the classification of religious organizations using pejorative terms like sect. Passage of this resolution will put the Parliamentary Assembly at odds not only with obligations under its own European Convention on Human Rights, but also at odds with the International Covenant on Civil and Political Rights. The resolution is not only a recipe for discrimination and intolerance, it will provide cover for arbitrary interference in religious life. You know, it is just very perplexing. My daughter goes to a Waldorf kindergarten in Hamburg, which is run by the anthroposophic institutions. Are they going to come after them? Let me conclude with a few words about the implications of this proposal with regard to the effort to protect the freedom of religion worldwide. Many members of the Council of Europe consider freedom of religion a priority concern in their engagement with other countries. And that is absolutely correct and appropriate, because freedom of religion deeply affects the enjoyment of many other human rights and is intrinsically among the most important rights necessary for human fulfillment. But the freedom of religion is seriously threatened in a depressing number of countries, threatened by discriminatory laws, by blasphemy laws, by the refusal of authorities to protect members of minority religions, even by laws under which people can be executed for changing their religion, laws that exist even in some states that are members of the UN Human Rights Council. The Council of Europe is respected around the world for upholding human rights standards. But if the Council of Europe embraces religious discrimination and interference by state authorities in the form of the resolution under consideration here, it will not only degrade its own standards, but also diminish its value as a model for others. Thank you.
Thank you very much, Dr. Rhodes. Very illuminating for us. Now, we've got time to take some questions. Do I see any around in the hall? Well, can I just ask one question? Oh, we have somebody in the back.
Well,
yes.
Is part of the problem is part of the problem the tradition in France of their own definition of sects? Is it something which is that? Is that behind it?
Thank you very much.
That's the opinion of many people that have analyzed this legislation, but you know, for me, that's not the big thing. I don't think that we should be focusing on one state or one group or even the beliefs of the sponsors of the resolution. I think we have to look at it at face value as to whether or not this is something good for the Council of Europe or not. That's my opinion.
Right, thank you very much, yes. Mr. Sheridan.
Thank you very much, sir. I want to pursue Donald's question because I have no understanding of what motivates this man to produce a report of this kind. And I want to know, with all your wide and broad experience of the subject, what do you think motivates this particular report, which seems totally malicious? And I mean, has the man been a victim of a sect? Do we know any of whether that's the case? Is his history a part of the reason for this report? What is the motivation for the report, do you think, sir?
I don't want to disappoint you, but I very hesitate to speculate about people's motivations, and I don't know the sponsor of the report, but I have had in the course of many years confrontations with the French authorities about their approach towards minority religions. When I was the executive director of the International Helsinki Federation for Human Rights in the 1990s, we made reports in which we criticized the French policy regarding minority religions with reference to international standards, with reference to international law. As a result of some of these statements, I was personally accused of being a member of the Church of Scientology by the head of the anti-sect institution in France, which, I mean, I don't care if anybody thinks I'm a member of the Church of Scientology in the least, but this was made some headlines, and actually, when I saw this, I was very happy because it gave us some of the best publicity we ever got. But I don't know the answer to this. I think it's a very good question, but I prefer to simply measure different proposals against the standards to which states are committed by international legal obligations.
Thank you very much. Yes, Jane.
Sorry about this. To follow up on Brian's contribution there, I mean, the point is that, or the impression I get, the thrust of this report seems to be against organised religion. And when I say organised religion, I'm not referring to any specific denomination, but there seems to be a general thrust, which is quite common to what I call humanist thinking and philosophy, which I'm not in any shape or form critical, because in my view of things, conscience, individual conscience, must always reign supreme, and I think that is one of the doctrines of most religious organisations. So, to follow up the point that Donald and Brian have made, I too am searching for the rationale behind this report, and it seemed quite apparent to me that the main thrust of it, particularly in the references to the Catholic Church and the Zapatero government's approach to certain aspects of basic Orthodox Christian teaching, it strikes me very, very strongly that somehow it's an engendering an effect and a thrust against organised religion. Now, I'm sorry if that sounds also full of intrigue and, how should we say, self-protective in terms of, but that's the way it strikes me, and I think it's an area that ought to be thought about deeply, because it is a complicated area when you come to tackle that with the notion of the fundamental expression of individual conscience. So I want to make that point because I think that it's the whole thing is worthy of rereading again. And I don't know whether you've got any comments in terms of what I'm saying, but I would like to hear some either whether I'm barking up the wrong tree or whether it's a worthwhile pursuit to investigate that line of thinking.
I'm not sure I completely understand what you said, but
Send you back to
okay. Religion is a very divisive subject. Religion brings people together, and in fact, the origin of the word religion refers to bonds between people. and bonds with God. And I think it's part of our human nature to understand our identity and the identity of other people with regard to their religious beliefs, and we classify one another by our religions, and we can be horrified by religious expressions which are at variance with our own in a very profound way. And it's a tremendous challenge of a pluralistic society to comprehend and to tolerate a broad variety of religious expressions. And of course, this is where, as I alluded to in my remarks, where a lot of the notion of human rights came from. It came from the challenge of religious toleration, and in the Enlightenment. And I think when we see documents like this, it just shows us that the lessons of rationalism, the lessons of pluralism and democracy, which societies began to learn in the Enlightenment, because human rights is an Enlightenment point of view. People don't like that, but that's a fact. It shows that these lessons still haven't really been absorbed by many people.
Thank you very much, Dr. Rhodes. I think we'll now move on to our second speaker. There will be another opportunity for questions when he's finished. We're very fortunate in having with us today Dr. Vincent Berger, who served for 7 years as a jurist consultant with the European Court of Human Rights in the building behind us. Now he lectures at the College of Europe in Bruges and Warsaw, as well as being a practicing lawyer in Paris. Dr. Berger.
Thank you, Mr. Chairman. I'm very glad to be here today in this room because, as you know, I left the court, the European Court of Human Rights, last year, so it's a pleasure to go back to Strasbourg. But on the other hand, I regret to be here because on 3 occasions, I contributed to the work of the Committee on Legal Affairs and Human Rights, because I was invited to present the case law of the court at that time in 2006, 2009 and 2013, and above all because I have a high esteem for the work of the Assembly, especially in the legal field, because as you know perfectly well, the Assembly has always been a leader as regards the legal developments in Europe, and its contribution to the European legal order is absolutely fantastic. That's why I regret, in a way, to be here and to disapprove fully the SAL report. I think that this report contains many passages which are of general scope and suggest that minors are used as a collateral or a pretext for an offensive against sex or religious movements. Of course, the draft recommendation deals exclusively with the protection of minors, so it corresponds to the official purpose of the report. But the draft resolution is aiming at much larger target. Indeed, half of its points do not refer to children and teenagers. They concern religious and spiritual sectarian groups, sectarian excesses, and cult phenomena. This is also the case with the explanatory memorandum, including important developments that have no relationships with minors. And the same applies to the summary of the responses by parliamentary delegations of member states to the questionnaire sent by the rapporteur, which was also often of a general nature. This report, in my view, is founded on unfounded premises. They are premises whose relevance is questionable. With these premises, some are explicit. The first one is that the European approach is necessary to protect minors, but this is far from obvious to the extent that, according to the rapporteur himself, many countries do not face serious cases of sectarian excesses affecting minors, and the vast majority of the states deem useless to legislate on this issue. The second explicit premise is that the sectarian excesses against minors are a deeply worrying phenomenon, and, I quote again, remains very worrying. This is contradicted by the available data on rare abuses recorded in some states. But there are also implicit premises. First of all, cults presented a priori the danger to minors. This discredits and throws suspicion on all non-traditional churches and communities and on all new religious and spiritual groups, while only a tiny minorities of these entities may or may have in the past given rise to such criticism. Second implicit premise, the legislation of member states, and particularly criminal law, is not sufficient to protect minors. This is, in my view again, a serious accusation against national legislators, suspected of negligence or even complacency towards a dangerous group. Third implicit premise, public services of member states do not perform their duties properly, in particular to ensure schooling and health of minors. Here again, this is an accusation aimed at national authorities. But then there are questionable models. In a veiled but yet clearly way, the draft resolution, and especially the explanatory memorandum, are campaigning for combative systems against sectarian excesses that are supposed to be effective and valid throughout all of Europe. First of all, there is the French model, with quotation marks. The French system in particular is presented as a model that should be adopted by all other member states, but it has not proven its effectiveness, as shown by the paltry number of abuse cases reported by Miviludes, this public official body in France in charge of the fight against sectarian movements or excesses. As to the Abu Picard law in France, it has aroused the concern of the Parliamentary Assembly, which invited the French government to reconsider it. It was in 2002, but without success. However, the draft resolution contained in the SAR report advocates repression, without, however, any reference to minors or the abuse of psychological and or physical weakness of persons. But this is a concept that lies at the heart of the French law, but is devoid of scientific value. Then there is the German model. The German system is also portrayed favorably, although less emphasized. Catholic and Protestant churches play an important role in, I quote, counseling victims of sectarian excesses and gathering information on sectarian groups, end of quote. So the rapporteur encourages the authorities to grant them financial support for this purpose. However, one can question the neutrality of such churches, which are in direct competition with cults. One must also consider the risk for the state to delegate its powers to private institutions, to the point that they become the armed branch of public authorities. My third point, or fourth point, is that this report is a kind of redundant initiative, in a way, because the SAR report doesn't provide any added value to the works of the Parliamentary Assembly on the issue, and is often only repetitions. The works of the Parliamentary Assembly on the protection of children against abuses led to several resolutions and recommendations in 2007 and 2013. And they have a triple character. First, they are very recent. Then they remedy what seems to appear in the eyes of the rapporteur, the deficiency of the European Parliament in the considered field. And finally, and most importantly, they cover all issues related to violations of the physical or moral integrity of children. So they appear, therefore, amply adequate. And on a general level, the Parliamentary Assembly adopted Recommendation 1178 in 1992 and 14.12 in 1999. And the first is about sex and new religious movements, the second about the illegal activities of sex. But the draft resolution contained in the SAL report includes two invitations that are already contained in Recommendation 14.12. That is, to provide teaching in the history of religions and the main philosophies in school. And second, to make sure that compulsory schooling is enforced and ensures strict, prompt, and effective monitoring of all private education, including homeschooling. The report, in my view, again, is based on inaccurate assumption. The SAL report notes that the European Court of Human Rights, I quote, has never issued judgments directly concerning minors who have been victims of the influence of sex, either directly or through their parents or persons caring for them, end of quote. And the rapporteur adds, in part explains that this in part by the specific nature of proceeding before the court and, I quote again, the lack of legal capacity to act of minors under domestic law. And he adds that it is hard to imagine a situation in which parents or legal guardians, followers of a sect, would turn to the courts to protect the children concerned against themselves. The rapporteur thus suggests that children are helpless, which is incorrect. Because according to the Strasbourg jurisprudence, states parties to the Convention on Human Rights have a positive obligation to protect individuals. This protection obligation applies primarily to minors and may be invoked before the national courts by relatives who deem that they are in danger. It is the same in Strasbourg. An indirect victim of a violation of the Convention can complain since he or she has a specific and personal connection to the direct victim. This would be the case of close relatives such as grandparents, aunts, or uncles. So the absence of Strasbourg court judgments concerning minors affected by sectarian excesses is therefore not explained by any impossibility to file applications meeting the condition of admissibility. In conclusion, if they were adopted as such, by the Parliamentary Assembly, the draft resolution and the draft recommendation would be likely to seriously undermine religious freedom and freedom of association guaranteed by the European Convention on Human Rights. Indeed, they cast aspersions on all new religions and spiritual groups that have emerged in Europe alongside traditional churches and denominations, in suspecting them a priori of sectarian excesses, unlawful and harmful to minors. So in my view, this text is not only useless, it is dangerous. But it's my personal opinion, of course. Thank you.
Thank you very much, Dr. Berger. Now, do we have questions for Dr. Berger? Yes, Mr. Roux.
Yes, Mr. Berger, thank you. I would like to interrogate you on a specific point of the report, which is the report is proposing a awareness session for judges and police about sects, and it's one of the points of the resolution. I know this exists in France, and it has existed in Germany, What could you say about that in regards to international human rights standards and international law, or European law, of course?
Well, I know that it's a common practice, a long, very long practice in France, but here again, I think we could have some hesitations, because if we don't have the guarantee that the speakers in such training would be chosen on a very fair basis, on that every tendency in the society or in the community could be heard and could expose clearly their position, then there is a real concern. But as far as I know, in France, this kind of training organized by the state, by the École nationale de la magistrature, is clearly oriented in order to fight the new religious movements and to suspect them that they are committing all the time excesses as regards minors or other parts of the society. So it's not the principle itself which can be challenged, but it's the way it is organized and presented by that's my personal opinion. Because we know that in some areas there are sometimes some excesses. That's quite true. Sometimes in the newspapers we can read something on this topic. But that's the problem, as I see in France, is that it's a general policy, a government policy, to orientate the judges and to create a feeling of hostility, which then can be used by the different courts in France in order to fight the new religious movements.
Other questions?
The cases that the European Court of Human Rights has so far, do you recall any case that a religious minority group or a religious group or so-called sect was condemned in the European Court of Human Rights, and if so, what was the ground for this? I know, for example, that Moldova had a case, the Bessarabian Metropole, where the Moldovan government was accused of lack of impartiality and neutrality concerning this new church that would have to be registered. And it is registered today, which, the decision of the Strasbourg court was very good to have this church to be registered in Moldova. But coming back to this, are there any decisions, taken by the European Court of Human Rights that could be in any way based for this report?
I don't think so. The strange thing is that the Article 9 of the Convention, which guarantees religious freedom and freedom of conscience and so on, is now very frequently raised in Strasbourg. There are quite a number of applications concerning freedom of religion. But as I said, in this Moldovan case, there are plenty of cases concerning the internal organization of the churches, or the lack of registration, or France, for instance, has been in violation of the convention on several cases concerning taxation problems, because the gifts of the money given by the parishioners of the Jehovah's Witnesses were, for a large part, taken by the state. But we don't have specific cases. For instance, the first case of this kind was an Austrian case, where there was a couple, and the mother became Jehovah's Witness, as far as I remember, and the children were given to the father because of the new religion of the mother. And the European Court said, no, it's not possible. It's a really discrimination, and based on religion, there is there is no indication that the father will not be able to take care properly of the children. So the religious ground of this judicial decision was considered as in breach of the convention.
Thank you. Any more questions? See, we have representatives of the press. Any questions from the press? Oh, there's one over here. Yes, Lord Anderson.
I've been to China and spoken to representatives of the house churches. One thinks of the blasphemy laws in Pakistan and so on. Is there any evidence that the French model is used by countries whom we wish to embarrass on their human rights policies? Saying, look, well, this is what France is doing, and clearly if the Council of Europe were to endorse this, is there a danger in your view that it will blunt any representations we make to China and other countries?
I'm sorry, but I don't know the answer, because as far as I don't think that in other parts of the world, the French model, as I said, is used or would be used in the near future. Of course, it's a possibility, but then I think nobody can prevent a third state to not belonging to the European, to the Council of Europe to have the same policy. But as far as I know, that I don't know any example of this kind. I'm sorry.
Yes, Mr. Rubin.
Yes, I just would like to answer to the question because I know some examples actually about that. You know, I know, for example, the example of China, when before the Minorities, what you call the Minorities, was called the Mills in 2000, and they went to China, and China was actually going after a group which is called Falun Gong, which are sort of Buddhist, neo-Buddhists, and they were justifying the fact that they were going against the Falun Gong because they were following the French policy, and France was obviously the country of human rights. Another example that I saw personally is Kazakhstan, when they changed the law in, I think, 2010 or 2011 on religions, and they said that every religions were to be deregistered, and they started to discriminate about many religious movements, Christians, Muslims, and new religious movements. And in the US here, the ambassador of Kazakhstan was saying, you cannot reproach that to us, because the USC was reproaching this new law. We cannot reproach that because we are just following the path of France, which is going after dangerous goals. So I think it's really a threat that if the Council of Europe endorse this report, that other countries will use that to justify discrimination.
Can I just hold that for our second question, and you can answer them together? If Mr. Sheridan has a question.
Thank you, Mr. Chairman. I'm genuinely frightened about a paper which seems to ostracize sect but refuses to define it. And doesn't that leave this council in an impossible situation by opening up the probability in this paper that sect doesn't only mean a religious organisation if they refuse to define it, it could be used for other organisations too. And that flies totally in the face of what this place is all about, doesn't it?
Yes, I share your opinion. I think it's like a Pandora box, which can be, this kind of text could be used, as Mr. Wu said, in many other areas or in many other countries. And as long as we all know that it's quite impossible to give a clear definition or legal definition to a sect or what is a sect. And but my impression was when I read this SAL report the first time that it was like to circumvent this difficulty and to use the minors as a pretext, as I said, to fight some kinds of religious movements, new religious movements. That's as if the children and the teenagers were the basis of this kind of struggle.
Thank you very much, Dr. Berger. If there's no more questions, I'll ask Mr. Galetti to say some closing words.
Well, yeah, I would like first to thank our experts. I think the arguments were very, they were very strong arguments that this report and the draft resolution must be rejected. It's up to the members of the Assembly, but I think in our political groups we can raise this issue, and this should not become a resolution. I mean, this is so, it will be, as Dr. Rhodes said, I think it will be a shame for the Council of Europe if we accept this resolution. It's very clear for me. I hope it will be clear for other colleagues in the Assembly. But once again, thank you for being with us today, and thank you for providing this expertise on this important paper. I mean, I call it important because, again, we produce papers that should be important, but this one is a real threat to religious freedom, and we cannot accept terms that are not defined, and they open that so-called Pandora box. So again, it's a malicious report indeed. So thank you once again. Thank you, David, for moderating this hearing today.
We'll give our speakers a